Hi, everyone, Joe Gentili from Saroff Gentili LLP. So let's say you applied for naturalization and you had your interview. It's been more than 120 days and still you have no decision. So you decide to file a lawsuit to make sure that you get a decision. You're entitled to one. And so the question is, once you file that lawsuit, can USCIS just deny your case to get rid of the lawsuit, to just basically moot the lawsuit and get rid of it because, okay, you wanted a decision, here it is, it's a denial, goodbye? The answer is that in general, they would argue that they can do that, but every court of appeals that has looked at this issue that I know of has determined that they can't do that. So the Second Circuit, the Fourth Circuit, the Seventh Circuit, the Eighth Circuit, and the Ninth Circuit have all looked at this issue, and all of them said that you can't do that. Once you, the immigrant, file a 1447B complaint to compel a naturalization decision, USCIS no longer has jurisdiction over your case. That means that a district court judge has exclusive jurisdiction on your case, which means that the district court judge is the only person that could approve or deny that immigration petition, that naturalization petition. And the other thing that a district court judge can do is they can remand the case back to USCIS with instructions on what to do with it, to decide it within a certain amount of time, for instance. So if you file the 1447B and USCIS just goes and denies your case, that denial will not be legally binding. It's not legally binding in those circuits that I mentioned, which cover a big chunk of the country. It covers the New York area, the West Coast, it covers the Chicago area. So in all those areas, it's settled law that it doesn't, that denial would not be binding. And in other areas of the country where it hasn't been decided, there's so much case law behind you to say that a federal judge has exclusive jurisdiction and USCIS can't issue a decision at that point, that I'd feel very confident that a judge in other circuits in other parts of the country would rule the same way. So the answer to that is USCIS in large parts of the country, it's settled law that once a 1447B has been filed, they can't deny your case at that point. A federal judge has to act first before USCIS can do anything. And then in other parts of the country, while it's not settled law, there are very strong arguments in favor of the immigrant that USCIS can't deny them at that point. A federal judge has to either decide the case or remand it back, but the federal judge is the one with the power and with the jurisdiction in that situation, not USCIS. If you have any questions, please feel free to reach out. And if this is useful content, if you're interested in immigration litigation, please subscribe. We try to put out a lot of content on these topics. Thank you.